If you think a high BAC automatically makes you guilty of DUI, stop. You're doing this wrong. A blood sample does not automatically mean this is the test, this is the result, we're done here. That's not how our system works, like I said at the top of this series. I want to continue our series on the trial defense of DUI cases by talking about ways in which you can attack a blood test. Now, as you may know, DUI cases often involve a test of somebody's blood or breath alcohol content. Sometimes that can be done through a blood test. And what happens is that phlebotomist comes in and they stick a needle in you, they draw a blood sample and they send it off to a lab, and they have that lab go ahead and test the blood sample for alcohol content. If the blood sample is above 0.08, that's considered a bad fact. It's something that you and your lawyer had to be prepared to attack. Is there any way to scrutinize it? It's important to really go over all of your drinking and eating habits on that day to kind of come with a rough understanding of whether the BAC, the blood test results, is consistent with what you would expect of somebody of your average size and age, etc. It may be a situation where you want to have an independent toxicologist take a second look, or even have that blood sample retested. That is something that can be done. One of the benefits of a blood sample is that it's preserved in some way, so that the lab that tested for the DA can hold on to it, and then you and your lawyer can maybe get that sample sent over to another lab of your choosing to go ahead and to compare the results. Another thing worth looking out for is when the blood sample was taken, was there a preservative included in the sample? Was there an adequate amount of preservative? California law doesn't necessarily specify a required amount of preservative, but some toxicologists might be willing to give opinions on what's an appropriate amount of preservative to be there. The point of the preservative is to make sure that when that blood sample is taken, the sample doesn't continuously ferment on its own and just create its own alcohol. The preservative is there to make sure that whatever blood is taken, the alcohol content allegedly found is reflective of where it was when it was inside your body at that time. It's a way to ensure the accuracy. When you're questioning a toxicologist at a trial, something important to note is just actually, believe it or not, just literally reading that blood test report. Does it literally say whether that sample was done in compliance with California Health and Safety Code Title 17? Does it literally say that a sufficient amount of preservative or anticoagulant is in there? If it doesn't, these are questions that, when put to a jury, may cause some jurors some pause. And that's the thing you have to understand. A blood sample does not automatically mean this is the test, this is the result, we're done here. That's not how our system works, like I said at the top of this series. It's ultimately up to the government to convince a jury that that sample is accurate beyond a reasonable doubt, such that they can prove either A, that you were too impaired to be trusted to drive safely, or B, that beyond a reasonable doubt you were actually somewhere above 0.08. One word of caution. Remember, I said somewhere above 0.08. Vehicle Code 23152B requires the DA to prove beyond a reasonable doubt that you are 0.08 or more at the time of driving. Remember, the issue is not whether you're drunk, the issue is whether you're being accurately measured above 0.08. So in a hypothetical scenario where things don't go as intended, perhaps after the closing, a lot of the jurors get together and they think that beyond a reasonable doubt your BAC was accurately measured at a totally different number. But if they all agree that you're somewhere above 0.08, that would still be a guilty. So it's not enough for them to get the memo that blood testing may have some inaccuracies, some problems that compromise its trustworthiness. You also have to convince the jury that they're not accurately putting you above 0.08, and that it doesn't accurately show that you're in fact impaired. And we'll get more into that issue in other chapters of this series. If you or anybody you know is concerned about fighting a DUI charge, please give us a call. Thanks, and stay safe out there.